Ladies and gentlemen, the final panel deals with parole ineligibility review proceedings. That particular rule has been included in these principally for the sake of convenience. It is enacted under a different, on a different legislative basis. It's the rule of the Chief Justice, passed pursuant to the authority given to him or to her under the Criminal Code. And it's included in these particular rules because it was thought best to have included in one place the rules which would govern criminal proceedings in the General Division. The panel consists of the chairman, Mr. Justice Gord Killeen. Justice Killeen is a judge of the court in London, Ontario. He was a graduate of the University of Ottawa, as well Osgoode Hall Law School, called to the bar in 1959, practiced in the city of Ottawa for 13 years before his appointment as a junior judge of the then county court in the county of Middlesex in 1973. He became its senior district court judge the following year. And since his appointment, he has participated in a number of continuing education programs for the Law Society, the Canadian Bar Association, as well the Canadian Judges Conference. At the far end of the table is Steve Skurka. Stephen is a criminal practitioner in this city. He has achieved a considerable degree of success in his relatively short term, by some of our dictionaries at least, at the bar. Practices with Austin Cooper and Mark Sandler, as well does both, I guess, principally trial advocacy, but to some extent appellate advocacy as well. And I recall him seeing him in a previous incarnation in prior years as a student at the Attorney General's office. Next to him, Brian Gover, to whom you have already been introduced, our executive legal officer and sometime member of the Crown Law Office Criminal, as it's presently called. Brian, as you will come to understand, dealt with some of the constitutional aspects of one of the predominant judgments in this particular area, as well is familiar with the process now, having seen it at the trial level, at least through his involvement with the court. Paul Culver is the one amongst us really who has firsthand experience with these applications as a prosecutor. Justice Killeen has it as well as a judge, but Paul is presently the Crown Attorney of the City of Toronto, appointed to that position in 1989. He's been a member of the bar since 1975, when he was appointed an Assistant Crown Attorney, the Deputy Crown for Toronto in 1987, and past President of the Ontario Crown Attorneys Association, and currently the President of the Canadian Association of Crown Counsel. Justice Killeen.
Thank you, David. Ladies and gentlemen, good late afternoon. Somebody outside said that this particular component of the program didn't have sex appeal, and I suppose I should welcome you as members of the Die Hard Club. You'll get your gold star on your certificate of attendance for being here so late in the day. The first thing to remember about these awkwardly called parole ineligibility reviews is that they are not a complete form of parole. In other words, there may be a misunderstanding out across the length and breadth of the land about what they achieve. My experience in the case I dealt with, Parker, in London and St. Thomas, is that the media certainly misunderstood them because their reporting was less than accurate, and it's important that you understand the real guts of what they do and are aimed at accomplishing. The purpose is, of course, that if someone has been convicted of first-degree murder or second-degree murder or even high treason, because it is still stuck amongst the inclusions, then after serving 15 years of one's term of imprisonment, this window of opportunity through Section 745 is available, and you can apply for a reduction of the period of parole ineligibility. But that does not mean that if a reduction is granted by the jury in question, that you will automatically be released. It simply means that you are then eligible for consideration for parole by the parole board. The 15-year rule and whatever sentence has been imposed upon you, whether it be 25 years under first degree or some period between 10 and 25 for second degree, that period can be abridged. But the abridgment only, as I say, has the effect of making you eligible for consideration for parole by the parole board. The other point that I want to make preliminarily is that there are some very interesting data available through the National Parole Board Office on how these particular applications are now coming home to roost, as I say in the paper that I've done for you. Let me just go through those data. As of February 1991, there are 600 offenders serving sentences with parole restrictions of 15 years or more. So there are 600 out there across the penal system. To date, 38 inmates have become eligible for judicial review under Section 745, and of that group, 12 have actually had hearings across Canada, and 2 applications are now, I understand, pending. 24 have not bothered to apply in that group. And the first judicial review case was heard as recently as 1987 in Quebec. Now, the outcomes of the 12 hearings have been as follows. Immediate eligibility for consideration for parole has been the decision in 5 cases. Partial reductions in parole restriction have occurred in 2 cases, and there have been outright denials of the application in 5. And of the 5 applicants who were granted immediate eligibility, 2 are at present on day parole, 2 have been granted unescorted temporary absences, of which 1 has since been terminated, and 1 has an application pending. Of the 5 who have been granted a reduction in years, 1 is on day parole and 1 has an application for day parole pending. Finally, and these are the stark statistics that we're facing now, 21 offenders have become eligible to apply for judicial review in 1991 up to the present date. 21 this year. And in 1992 and for the next 10 years thereafter, the number of offenders becoming eligible for review varies from between a low of 25 and a high of 52 per year for that next 10-year period. Thus, on an average, 41 offenders per year will become eligible to apply across Canada. So this is a cottage industry that we're creating here, and I can envisage the evolution of a small cadre of criminal lawyers, some of you perhaps, who will be hopping from province to province doing these as skilled experts and getting quick calls to the bars of the various provinces across Canada where these cases are maturing right now as we speak. It is a significant number of cases, and probably somebody's going to have to write a quick textbook about it. So with that, we're going to get into some interesting areas, because while the statute has a seeming simplicity on its face, the rules, which are intended to fill in the interstices between the statutory provisions, have the effect, I think, of making the picture somewhat more complicated than it first appears to be under the stark words of the section itself. I'm going to invite Steve to discuss some of the constitutional questions that have arisen already around Section 745? I'm sorry, Brian.
Well, it's striking for anyone to review briefly Rule 50 because two things jump out at you. First of all, the rules mandate disclosure by the applicant of evidence to be led by him or her at the hearing. And that is Rule 50.09 sub 6. Second thing that is striking is that the applicant must lead evidence before counsel for the Attorney General. There's another matter that is striking as well, and that is that the burden of proof is more akin to the civil burden, and the jury need not be unanimous. But let me return to those two matters, disclosure by the defense and the requirement of the applicant leading his or her evidence first. These items were considered by Chief Justice Callaghan in the first of the Ontario cases to be determined, Viancourt, and the ruling of the Chief Justice dealing with the constitutional issues in that case can be found at 1988, 43 Canadian Criminal Cases, 3rd Series, page 238. The Chief Justice held that the rules did not violate the general rights to be presumed innocent and to remain silent, coming within the purview of Section 7 of the Charter. He pointed out that while those rights are referable and integral to the general protection of life, liberty, and security of the person contained in Section 7, they were rights to protect an accused person in the process. But in an application under Section 745, the applicant is no longer accused of criminal conduct, but has been convicted, and his guilt or innocence is no longer an issue. In my view, there is some Section 7 right because the liberty of the accused, the convicted person, is at stake. But the notion that the applicant is in some way denied a fundamental right because he or she has to disclose evidence or has to lead evidence first has been held not to violate Section 7 of the Charter. The Chief Justice concluded, consequently, the purpose of the principles embodied in the presumption of innocence and the right to remain silent is not applicable. Now, I might point out that issue was taken with that ruling, and an appeal was launched to the Ontario Court of Appeal against the determination ultimately made by the jury. The Crown moved to quash the appeal on the basis that there was no right of appeal from the determination. And you'll notice that in the paper that Mr. Justice Killeen has prepared, at the conclusion it stated that there is no means of reviewing the determination. Well, the Court of Appeal held that in Viancourt. The decision reported at 49 Canadian Criminal Cases, 3rd Series, page 544, and the critical portions are at pages 551 and 552. Essentially, the court held, speaking through Mr. Justice Brooke, that the right of appeal is a purely statutory one, that this type of review process could not be characterized as being integral to the sentencing process, and that the only court of competent jurisdiction for the purposes of fashioning a charter remedy was the court composed of Chief Justice Callaghan with the jury. In other words, within the Morgentaler, Smoling, and Scott formulation of what constitutes a court of competent jurisdiction, the Court of Appeal, because it lacked the statutory jurisdiction as a court of appeal to hear the matter, also lacked any jurisdiction under Section 24(1) of the Charter. I might, just in closing, comment that in Viancourt, the Crown took the alternative position that if there was any jurisdiction to review the decision of the jury, then that jurisdiction was an extraordinary jurisdiction held by the Supreme Court of Canada under Section 41 of the Supreme Court Act, because the court composed of the judge and the jury was the court of last resort for the province. The Court of Appeal expressly declined to comment on that matter, holding that the jurisdiction of the Supreme Court of Canada is for that court to determine. There was an application for leave to appeal in Viancourt, and that application was, as is the practice in the event that applications are dismissed without any reasons.
Thank you. I'd like to call on Steve to discuss some of the prerequisites for the application itself, what has to go into it and what has to be provided along with it.
Well, fortunately, the forms that are appended to the rules in this area clearly set out what has to be included in the materials of the application. And really, it's simply a screening process that will take place when the application reaches the Chief Justice's level. The main criteria, of course, is that the individual applicant has, by the time the application is served 15 years of the respective sentence. And that, of course, because murder is quite unique, if the person is being denied bail ab initio, will include the period from the time of his arrest, not merely the time that he or she starts serving their sentence. The materials that should be included in the forms that are set out at the very last two forms included in your materials include reference to the date of arrest and the institutions that the individual has been placed since the time of the arrest, the institution that he or she is being served the sentence since the time of sentence, the actual offense, the actual sentence, the criminal record, and the grounds relied upon for the application. And the grounds really would be just a cursory reference, in my view, to the criteria set forth in the application, which be because of the character of the applicant and his conduct while serving a sentence, in view of the nature of the offense, that the individual applicant is asking to have his or her parole eligibility date reviewed. And that would simply be fulfill all the criteria set out in Form 20, and then in Form 21, there's also an affidavit that has to be included in support of the application for review of parole ineligibility, and it's really quite an abbreviated affidavit, and really can be filled out quite quickly. So it really, just putting it succinctly, doesn't take much once the essential criteria are met to have one's application put before the Chief Justice.
Does it help, Stephen, to have a knowledge of prison law generally?
Absolutely, because evidence can be called, and we'll be getting into this somewhat later, but evidence can be called by the applicant, and the various knowledge of prison settings and the various correctional offenses that one may commit, the eligibility for parole, all of those are factors that may benefit the applicant when he or she brings forward the application. So this is certainly an area that one should have some knowledge of. I know David Cole, for example, brought the first application. He called or attempted to call someone from the parole board to deal with what happens after someone receives parole, and certainly that knowledge is important. He also called psychiatric evidence. He also called a prison chaplain who dealt with with Mr. Viancourt, and called other evidence. So his knowledge and expertise in that area served him as well as it could have in bringing the application.
Are there any other comments about the application or what the prerequisites to the application are?
Well, I would only add this, that merely satisfying the minimal criteria shouldn't in and of itself suggest to defense counsel that the timing of the application should be brought immediately at 15 years. It might be premature at that time. For example, the individual might have a horrendous history in the correctional institutions that he or she has been serving their sentence, and over the last 2 or 3 years may have shown a different pattern, where in fact they appear to show some element of rehabilitation. It might be appropriate to wait another 2 years, even though one's eligible at 15, just to show that pattern extending over a 5-year period rather than a 2 or 3 year period. So the only point I would add, and I know Paul Culver has some views on that mere eligibility shouldn't in and of itself be the sole criteria. One should look at the various factors in place, the character of the applicant and his conduct while serving his sentence before one brings an application.
Brian, did you have something to add?
Well, I'd just like to refer to 2 cases on the question of meeting the preconditions for the application. The first is Frederick, which can be found at 1989 52 Canadian Criminal Cases, 3rd Series, page 433. And Frederick essentially stands for the proposition that Section 745 sub 1 means what it says about the applicant having served 15 years prior to making the application, that no anticipatory application can be made in order to expedite the process and therefore go immediately to the hearing stage on the day at which the applicant has served his 15 years. The second case is Parker, and this is a preliminary determination or ruling made by Mr. Justice Henry in the case that Mr. Justice Killeen ultimately ended up presiding over at the hearing stage. And in Parker, which can be found at 1990, 73 Ontario Reports 2nd Series, page 193, Mr. Justice Henry held that although Section 745 sub 1 refers to 15 years, that where the police have had the grounds to arrest an accused, or pardon me, an applicant at some stage but have held off for some reason, then even in the absence of some ill intent, the court can fashion a remedy under Section 7 and can deem the time for the purposes of Section 745 sub 1 to have commenced when those grounds for arrest existed. And in Parker, and of course Mr. Justice Killeen will explain to you what happened in Parker in greater detail, but in Parker what happened was the applicant had committed 2 murders in Ontario, had fled to Alberta, had murdered someone else there, and was brought to trial in Alberta before being tried in Ontario in respect of the murders committed in the St. Thomas area. And the police investigating the Ontario murders had the grounds to arrest Parker at an earlier stage, but decided not to in order not to disrupt the Alberta trial. Mr. Justice Henry held in the case that I've given you the citation for that a violation of Parker's Section 7 rights took place because Parker was denied the benefit of the clock starting to run from the time of arrest. And of course, in terms of murder only, we have this extraordinary provision in the code that sentence is calculated from the time of arrest unless judicial interim release is granted in the event of subsequent conviction.
Paul?
Just a couple of quick comments. Doing Valancourt was a strange experience for me as a Crown because for once I was in a situation where I had to a right to ask disclosure from the defense. The onus was on the accused or the applicant, and there was no right of appeal, as we later found out. So it was quite a unique experience. The other thing that, with respect to the 15 years, one of the lessons before Valancourt and before Parker, there was a notion in the corrections community that all these lifers were there waiting for their 15 years to come up, and they'd bring these applications. If any of you act for anyone that it becomes in this situation, I think you have to sort of discuss with the person that there is a substantial element of risk. And the lesson that Valancourt and Parker teaches is that if you bring your application and you're not successful, and if indeed the jury doesn't like you, then you're shut out for another 10 years. So I suppose the adage is, like the Gallo brothers, sell no wine before it's time. These applications shouldn't be brought prematurely. You have a rather substantial burden of convincing a jury that your client who was convicted of first-degree murder should be gradually released back into the community. And as you'll see from the results in Valancourt and Parker, those two people sort of gambled and lost. Valancourt's now shut out for another 10 years as a result of the result in that application. So just because someone has served their 15 years, there's certainly a lot of tactical considerations to be taken into account. For example, if you had a client that was convicted of extreme violence against a woman, for example, I wouldn't like to be hearing that application anytime this month with what's been going on in the media. But I think you should be aware that there is a substantial risk involved in bringing these applications prematurely.
The reason for that is in the legislation, because the jury is required, if they reject the application, to fix another date at or after which the applicant may bring an additional fresh application for review. So the legislation empowers or contemplates subsequent applications at the decision of that first jury hearing the first review. In both Vaillancourt and Parker, the jury very cleverly, expressing its views, fixed the date for the next application to run on the date when the given applicant had his 25 years served, or in Parker's case, his 20 years served. So if you make a tactical error in bringing the application prematurely, that is what the jury might do to your client. Deny him forever during the balance of his 25 years or 20 years, whatever it might be, denying him the opportunity to bring that fresh application. Of course, some juries might not be so harsh in their assessment of that final question on the series of questions they must answer. What happens, Paul, to the application that has been launched by the lifer?
It goes to the Chief Justice, who makes, as was indicated, the determination whether or not there's the 15 years has run, and usually that's not that difficult. The Chief Justice then designates a judge of the General Division to hear the application, and following that, notice is given to all concerned, the Solicitor General, the Attorney General, and in most cases it'll be the local Crown Attorney that appears as agent for the Attorney General on these matters. And a date is fixed for what's termed a preliminary hearing, which in some ways is like the traditional preliminary hearing in the criminal justice system, but in a lot of ways isn't. And it's much more informal. There's usually no evidence called at the preliminary hearing, but it's at that stage that the judge has the option to order what's called a parole eligibility report. I say optional, but I can't comprehend, quite frankly, a situation where one of these reports would not be ordered by the judge. It's really, I can't conceive of carrying out one of these applications without it. And it's also at the preliminary hearing that the defense or the prisoner advises the court what evidence will be called. Informal rulings are given on evidentiary issues, and in Valancourt and in Parker, that's where the whole range of procedural matters are worked out. In Valancourt, it was a very strange situation, because all our training as lawyers is dealing with precedent, and there's almost always, in a sense, that you can look back and see what was done in the past. Well, in Valancourt, there really was no precedent. Valancourt was the second application that had ever been brought, and the other one was in Quebec, where my understanding is that the Crown really didn't oppose the application. So it was sort of a strange experience, sort of, I won't say making the rules up as you go along, but the Chief Justice had to make a lot of determinations, and with respect to the procedure, that there was no precedent for. But really, the preliminary hearing is where all these issues are resolved. It's usually it's contemplated to be a rather informal process where basically both sides lay out what they intend to, types of evidence they intend to call, and at that stage, it's in the nature of a voir dire that the presiding justice would make rulings as to what evidence is considered to be admissible before the jury and what isn't. In both cases, both sides sought to adduce different types of evidence that ultimately the court held to be not admissible, and we'll deal with that in a minute.
It seems to me that the report that Paul has referred to is a seminal document in this entire process. And I agree with him that it's unlikely that a hearing judge would ever even think about refusing an application for the preparation of one. It is in Parker, where I presided, the report was prepared by a senior parole officer of the Corrections Service, and equally and similarly in the Vaillancourt case, a senior parole officer also prepared that report. What you're going to get into at the first day of the preliminary hearing, and it really is a two-stage process. You're going to have an initial day which might last a half a day or a full day, at which you will thrash through an outline, if you can get it in coherent form then, from each lawyer as to the kinds of evidence he wants to call and who he wants to call, and then the ordering of the report and any ancillary questions that require resolution at that stage. Then the proceeding is going to be adjourned for perhaps up to 3 months, because it will take, in my experience at least, and I think Paul will confirm this in Vaillancourt, it will take at least 2 to 3 months for the Solicitor General's office to instruct an officer to prepare the report. And it's going to take about 2 to 3 months to get that report prepared and then delivered to the court, the judge, and counsel on the case for the Crown and defense. Then the judge has to reconvene the proceedings, and you go into the second stage of the preliminary hearing, where the judge will probably have to hear viva voce evidence from the officer who prepared the report, because in my experience at least, it would be unfair to prevent counsel from examining him to review the report, highlight points where it might be inaccurate or misleading or unfair, and then make rulings on what should be excluded from the report. Now, you can get through all of those things, but it's going to take those 2 days or 2 stages to be got through. It's unavoidable. And I think in Vaillancourt, the preliminary hearing proceedings only took perhaps a half day or a day on each occasion when it was convened, and in my case it took a half day on each day. So there you have the guts of the preliminary hearing. Now, there are some problems with it, and I'd like to hear from Steve first on what he perceives to be some of the problems with the preliminary hearing.
One of the criteria that ultimately the jury will explicitly have to take into account is the nature of the offense, and that will be something that will inevitably have to, in terms of the specific nature, what was the nature of the offense, be thrashed out at this preliminary hearing, I would think, so that by the time the matter gets to trial before the jury, there is some agreed version as to what that offense was. And I can see it as being extremely problematic. Starting off with the proposition there's been a conviction, there's obviously certainly minimal criteria by which the Crown can suggest that the elements of the offense are present. And I don't think that it's a matter of suggesting that the offense be retried. But there might be alternate theories that the defense put forward, and one might have more aggravating features than the other. There might be aggravating features of the offense itself that may be in dispute. For example, there may have been gratuitous violence after the murder was committed, and then the issue is the jury didn't have to consider that in coming to the deliberation. Should that component be present before the jury in this when there's really no finding by the jury with respect to it? And then in what form is that summary of the nature of the offense put before the jury? Is it an agreed statement of facts? Well, that's in fact what happened in Vaillancourt, and essentially it appears what was done is the facts were taken out of the Court of Appeal judgment, and that was thought to be a fair representation of the facts, and simply with some modification reproduced as the agreed statement of the nature of the offense. But that is one area that I could see being somewhat problematic and would have to be dealt with at the preliminary hearing. And the second area that I could also see being problematic and would also have to be dealt with at the hearing would be what input should there be of the victim's family. By definition, the victim is dead. The victim's family's view as to whether or not the individual applicant should have their parole eligibility reviewed and reviewed downward, and that's another consideration. I have strong views as to how that should be achieved, but in any event, that's something that will have to be dealt with at the preliminary hearing. But those are two areas that I could see being quite difficult and complex.
What about that victim impact statement, Paul? What do you think about it? Would you try to get victim impact evidence in, and did you in the Vaillancourt case?
I did in Vaillancourt. I tried to get two types of victim impact. Vaillancourt was the murder of a police officer in 1972 and had the unusual feature that there was an eyewitness to the murder, Constable Maitland's partner, who was shot at and was still alive. And I wanted to call his partner for two reasons, as an eyewitness to the murder and also as a victim of the deeds of Vaillancourt. He suffered long-term psychological problems as a result of being seeing his partner killed and also being shot. Chief Justice Callaghan, basically, as he did throughout, his ruling was that the purpose of this application was not in any way to relitigate the offense, and that application was denied. The other type of evidence that I tried to call was victim impact evidence. In the Vaillancourt case, the Constable Maitland was married with two young children when he was killed, and his wife was pregnant with a third. And I thought that it would have been appropriate for this type of hearing to call this what's commonly known now as victim impact statement, and statements from what was the effect on these children from growing up without a father. And again, Chief Justice allowed a limited, certainly didn't allow the traditional filing of a victim impact statement, but we sort of reached a compromise in that the agreed statement of facts was amended to outline the victim's circumstances, the fact that he was a police officer, had this family, and a small mention of his record as a police officer, which was commendable. So those are certainly definite problems, and I think still live issues for future hearings with now the as the victim legislation becomes more and more entrenched in the criminal code. I still think it's a live issue for future hearings.
In Parker, I disallowed victim impact evidence as to the family, the effect on the family of the deceased. Sandra Leonard in the audience conducted the defense, the applicant's position, and will remember the case vividly, I'm sure, in its totality. But my rationale is that the victim impact evidence is mandated under the code at the sentencing hearing. And logically, that's where it should be. This is not an extension, ladies and gentlemen, of the sentencing hearing or of the trial per se in any way, shape, or form. It is a unique hybrid creation of Parliament. It is a compromise by Parliament to create a light at the end of the tunnel a window of opportunity, as I said earlier, when that particular inmate has been sentenced to 25 years or whatever, less than 25 on a second degree, he has been sentenced to. This is something sui generis that does not exist, so far as I'm aware, anywhere else in the Western world. And it being apart, separate and apart from the trial per se and the sentencing hearing per se, it is my view that the direction of the hearing must be towards an examination of whether this particular accused has sufficiently rehabilitated himself in the intervening several years such that he is no longer a meaningful risk and is deserving of the ameliorative treatment that the reduction in the years of ineligibility will create for him. Therefore, in my view, it is centered, the hearing, on the applicant and his performance, and to bring to bear upon it considerations going back in time to the horrific events, the admittedly horrific events of the crime itself, would profoundly distort the proceeding. However, that's just my view.
And if I could just add to that, the hurdle one has to overcome at these hearings is tremendous, because you don't have an accused here. You have someone who's been found guilty of necessarily a heinous crime. And the circumstances of that crime are already going to be before the jury, and the prospects are already there, even with that, of inflaming them, but properly before them. To go further and then to add to that the victim's family's thoughts as to what should happen or the impact upon them would surely distract the jury from its true purpose here. And I would just simply endorse Justice Killeen's comments in that regard.
I suppose we should go back and just make one point about the how this proceeding wends its way. After the Chief Justice designates a judge to conduct the proceedings, there arises the question of where will the proceeding take place. The statute and the rules really are not terribly helpful on that point, and as far as I'm concerned, the practice is going to be, as I see it evolving in the cases that have been held, that the Chief Justice will probably designate a judge in the region where the original proceedings occurred, the original trial occurred, and probably the proceedings will take place in the county where the original proceedings took place. But in Parker, I modulated that with the consent of counsel. I conducted the first stage of the preliminary hearing in St. Thomas where the original trial occurred. Then we moved on consent for the trial to London, simply as a matter of convenience to counsel. But I would say that the general practice will be that you will get a judge designated from the region where the original trial occurred, and then you can work out common sense arrangements with that judge as to the precise location of the preliminary hearing and or the trial and or the jury hearing, as it should be called properly. Perhaps we can go on to some problems with the contents of the eligibility report as you experienced them in Viancourt briefly, Paul.
Without going into great detail, the parole eligibility report basically is a summary of the history of the inmate as he has over the last 15 years, and generally includes all the major psychiatric assessments that were done at the time that he or she was convicted, and as well basically the opinions of prison psychologists, psychiatrists, caseworkers within the prison system, and also contains a very detailed summary of the offense record of the prisoner while in the various federal institutions. And for those of you that aren't familiar with that, there's a sort of a justice system within the corrections system, and there's a whole range, a whole category of offenses that inmates are charged with and tried, and basically you have a record within a record. For Valancourt, he had a substantial prison record in the early years, mainly for trafficking in narcotics. but ranging from possession of a large quantity of drugs to the sort of ominous endorsement possession of contraband, which, as it turns out, was a 6-volt battery that he was not authorized to have, but he had smuggled into the prison so he could keep his transistor radio on at night. So you'll see a whole range of offenses, and it's important that if you're bringing one of these applications to make sure that what might sound like ominous offenses are recognized for what they truly are. On the other hand, what might not seem like ominous offenses sometimes are. For example, possession of narcotics, it doesn't always give the quantity, and in one situation with respect to Valancourt, we were quite surprised at the quantity that Valancourt had within Archambault, the notorious federal prison in Quebec. The other thing that is a problem, certainly for the Crown and maybe for the applicant, is, as is the case when accused or prisoners talk to psychiatrists, they will base their opinion on invariably often base their opinion on the version of the facts that was given to them by the prisoner. And quite often the facts that they get from the prisoner were not the facts that came out at trial, and in fact in Valancourt that was the case. One psychiatrist based his opinion on the fact that Valancourt indicated to him that he was cornered, he panicked, and it was almost self-defense, when in fact Valancourt shot Constable Maitland through the chest once and then fired the second fatal bullet at Constable Maitland when he was lying on the ground defenseless, which is totally contrary to what he told the prison psychiatrist. So, of course, when the psychiatrist gave his opinion that Valancourt was not dangerous or not a danger to the public, it was based on the original version of events that was incorrect. So, again, it's important if you're acting as Crown or the applicant to sort of thoroughly canvass how these opinions were arrived at, because you'll see a tendency, although I think Corrections Canada is going to pay a little more attention now because these things are a reality, you'll see a tendency in a lot of, at least I have, I won't say sloppy work, but certainly work done without the intention that it would someday become public knowledge or the source of cross-examination.
Anybody else with any comments on the report itself?
Well, just that it obviously is going to be central to the jury's determination because it speaks to two of the three criteria mentioned in the code, they being the character of the applicant and his conduct while serving a sentence. And just as Paul has already referred to, Mr. Valancourt probably predetermined the issue by his statements to the people that interviewed him, being the psychiatrists and others, when he gave different versions of events than the agreed statement of fact. So it's obviously something that, being as central as it is, counsel is going to want to be sure to tune into and meet with the applicant before the report is prepared and to go over the various issues, such as what is the nature of the offense before the report is prepared. It would seem to me, and I agree with Paul, although it's discretionary, I can't conceive of a situation where this report isn't going to be ordered and, as I say, will be threshold and central to the jury's determination.
The report will give both sides, ironically, a motherlode of information that they might not have otherwise expected to get themselves. Since it's being prepared after the first stage, the first day of the preliminary hearing, you get a crack at the officer, or should get a crack at the officer at the second stage day, where you can question him, and you might draw out of him at that stage even more information, which leads in various directions. That's why I call it the linchpin of the proceeding, or of the proceedings. And it is essential to get to know the lingo of the prison underground. Because you see such terms as contraband in there and so on, and it may be innocuous in one case and not so in another. In Parker, you had him being convicted of possession of contraband. Well, the contraband in one instance was a pair of green polka dot bikini underwear. which wasn't a very earth-shattering offense, I'm sure, and it was explained away. And then there were charges laid within the prison system, but were dismissed. Well, obviously, there should be no reference to that kind of thing, in my view, in the report. It's unfair to the applicant. And Chief Justice Callaghan, in his brilliant judgment in Vaillancourt, deals with many of those questions. And you should read his reasons because it's just an absolutely brilliant analysis of the whole scope and reach of these proceedings. And I think he's right on virtually every point he addresses in his reasons. So that's a good backgrounder for you, his judgments in the case. Let's move on to considerations at the hearing proper, the jury hearing itself. How do we get it started? Can I deal with you, Paul, first on that? What special considerations do you think are involved in impaneling the jury and the like?
The process, subject to a matter that's of some debate, is exactly the same as the impaneling of a jury on a guilt or innocence trial, and probably a lot of the same considerations would apply. You may want to challenge, you may want to have the justice issue the same kinds of general directions to the panel before you even get into picking a jury. For example, if it's the murder of a police officer, you probably wouldn't want police officers or police officers' families on the jury. And those types of situations can be dealt with as they were dealt with in general instructions to the panel. With respect to the impaneling of the jury, it proceeds in every respect as you would with a normal criminal trial. There's some issue as to whether or not the rules have now eliminated the Crown's power to stand aside, but I understand His Honor did indicate that in the Parker case, the Chief Justice, again before the rules were amended by Justice Watt, did allow the Crown to exercise up to the 48 stand-asides that are traditionally there for any trial. But really, basically the same issues with respect to jury selection apply to this type of hearing.
Any comments, Steve?
Well, I'd only say that I'm a proponent of the view that the stand-aside procedure is done away with. Clearly, by the way the rules are set out, there's specific reference to challenges, and in Rule 50.10 sub 2, and it indicates that the applicant and the Attorney General are entitled to the same number of peremptory challenges as they would be entitled to if the applicant were being tried for the offense that is the subject of the application. In the case of second-degree murder, 12. In the case of first-degree murder, 20. And subsection 1 is modified explicitly by subsection 2, so it might be my respectful view that that it really is, it sets out the parameters as to what the challenges are. The only point I would make is that Paul referred to the vetting procedure that occurred in Vaillancourt. It was with respect to anyone who had a family member who was a police officer or a bank teller, being a robbery of a bank before the murder of the police officer. I hold of the view, and I know I hold it uniquely on this panel, but I hold to the view that there should be a further vetting of individuals who abide by a belief in capital punishment. I can't conceive of anyone who believes in capital punishment fairly giving his or her attention to a consideration of whether or not someone who originally had a sentence of greater than 15 years should have their parole eligibility reduced. By definition, they already would at least superficially appear to be of the view that the person got a break already. And I would suggest that if someone holds to the view that capital punishment is appropriate for situations of murder, that they should be vetted, that those views should be vetted and they should be excluded from a jury panel. But I know that that matter was addressed in Vaillancourt and was in fact rejected by Chief Justice Callaghan.
For what it's worth, I don't believe that a challenge for cause procedure is appropriate in respect of this kind of hearing, it being a hybrid of a civil and a criminal proceeding, with the civil burden of proof applicable and so on. If you look at Rule 50.10, 1 and 2, and read them intelligently, it seems to me you come up with the equation and answer that there shouldn't be challenge for cause. It may be that the judge at the opening with the panel at large can deal with the question of whether certain people might be excluded from the panel, but I would be a hard sell even on that. In fact, I would think that that the stand-aside question is dead now. I did not, incidentally, in Parker, allow the Crown stand-aside rights. I held against that, even under the old rules that preceded these. And as it seems to me, these rules reinforce that position I took then, that the Crown doesn't have stand-asides. They simply have equal challenges with the applicant. And it seems to me subsection 2 of Rule 50.10 clarifies that and makes that clear by implication. So I think stand-asides are gone in these proceedings. Each side has 20 challenges in first-degree murder cases, and only 12 challenges if the original charge was second-degree murder. If you take a look at the challenge sections of the code, you will see that there are, as I read them, that there are only 12 challenges if the original charge was second-degree murder. If the original charge was first-degree murder and led to a conviction on second degree, then you start with the 20 because that is what the original charge was. But those are the rights of stand-aside as I understand them. Can we just briefly, before we end, go through a few more matters? At the trial, who's going to be calling evidence first, and who is going to actually call evidence? Because it's interesting that in both Vaillancourt and Parker, the Crown did not call evidence. Steve?
Well, the onus is clearly on the applicant. He or she is bringing the application so that he or she will then open to the jury. Interestingly enough, I've spoke to Paul about this. The Crown was entitled to open after the defense, and then, of course, was precluded from opening at the commencement of their case, and in Vaillancourt, the Crown called no evidence. The applicant then will call the evidence to satisfy the onus, and at the conclusion of the evidence, the Crown then is free to call further evidence, and then there is provision for rebuttal evidence by the applicant after the Crown closes its case. So that's the order and sequence in these hearings.
And you're in no doubt that the civil burden of proof is on the applicant.
That's correct.
No higher, no lower.
That's right. It's not a criminal trial, and that has to be absolutely clear. And one of the features of that is that it's a different burden of proof than you would find in a criminal trial, and that specifically is dealt with and within the rules. And in terms of the rules of evidence, they're set out, or the parameters are set out in 50.10 sub 3, where it indicates that the judge may, subject to the rules of evidence applicable in respect of a sentencing hearing, admit any evidence that the judge considers credible and trustworthy.
I have some difficulty with the phraseology of that particular sub-rule. It seems to me there's an inherent inconsistency in saying that the trial judge or the hearing judge can admit evidence which is credible and trustworthy, which would embrace hearsay, of course, and all manner of evidence, which could be credible and trustworthy, and then go on to say, but that is subject to the strictures on evidence in a sentencing hearing, as reflected in Regina versus Gardner, of course, in the Supreme Court of Canada, which held, if you read it, that if there are disputed facts, that the Crown must prove those disputed facts beyond a reasonable doubt. Now, I think whoever put that rule in there somehow has garbled, with respect, the admissibility parameters for the judge. How can you have a proof beyond a reasonable doubt standard of admissibility extant in a proceeding which is controlled by implication by the civil burden of proof? So I think that the standard should be, is the evidence credible and trustworthy? And the second branch of that criterion that's included should be ignored or quietly interred, perhaps would be a better way of putting it. What about the addresses of counsel, Brian?
Well, of course, one of the issues in Viancourt was the order of addresses of counsel. Steve has touched on the opening addresses, and in connection with the closing addresses, the rules also maintain that order. And consequently, and if I can just locate the rule, in section, Rule 50.10, sub 12, it's stated, where after the evidence is presented at the hearing of an application, the judge considers that section 745 sub 1 applies to the applicant followed by the Attorney General shall address the jury. So again, the applicant bears the onus of going first. Counsel for the Attorney General goes last.
Any comments on that, Paul?
No, again, that was challenged in Valancourt, the constitutional validity of that, but a lot of things were challenged, including who sits where. David Cole wanted what he perceived to be the advantage of sitting closest to the jury, normally where the Crown sits, so he asked Justice Callaghan to make a ruling on that, and because it was analogous to a civil proceeding, and Valancourt was the plaintiff, he allowed David Cole to sit closest to the jury. So not only was I in a strange hearing altogether, I was also in a strange seat over the other side of the courtroom. But
one of the last questions, if not the last question, is what kind of unanimity is required of the jury, and the answer is set out in the code. It says that the determination shall be made by a two-thirds majority, two-thirds of the jury. But the problem with that is that there have to be at least 3 questions answered by the jury. And what does that magical word determination mean? Does that embrace all 3 questions? And if it does, as it surely must, then may different 8-person groups answer the 3 questions? Well, in a civil case, as you well know, under Section 121 or whatever it is of the Courts of Justice Act, it is expressly stated that 5 out of 6 must agree on any given answer, and that the same 5 out of 6 don't have to agree on each answer if there is more than one question put to the jury in the civil case. Here, you don't have any spelling out. It just says the determination must be made by a two-thirds majority. Chief Justice Callaghan instructed his jury that the 8 people can be differently constituted for the answers to the individual questions. And as I remember it, I agreed with that in my charge to my jury, somewhat haltingly, but one must show deference for one's chief. But there is an argument there that it has to be the same 8 people because there isn't a spelling out of the option that is included in civil jury cases in the Rules of Practice and in the Courts of Justice Act.
We have one question about the growth industry.
One question?
We have one question about the growth industry, and it's being directed to Steve Skurka.
Well, the question is who pays defense counsel to bring these applications, and I'm asked, is it Ontario Legal Aid Plan? I specifically don't know the answer to that, but I would imagine that legal aid would fund these matters. I don't know if specific provision is in the legal aid manual, but I can't imagine that they wouldn't fund them in the way that they would fund an appeal or a review. And this is a review, and that would be really the extent to which I could answer it fairly.
Perhaps I could mention for you an outline of the witnesses who were called in the Parker case. Ms. Leonard called William Dunbar, the parole officer who prepared the eligibility report. She called Carol Sparling, the regional training coordinator of the National Parole Board, to explain to the jury, and this is critically important, to explain to the jury what in hell the parole practices are of the National Parole Board. Now, in Vaillancourt, Chief Justice Callaghan explained that himself to the jury, largely. But I think, with great respect, that if Carol Sparling or somebody like her is utilized, the jury would have a much more fixed and focused picture and understanding of the parole system and what really happens to a lifer. Now, the option would be to get an agreed statement of facts or an affidavit from someone like Carol Sparling, who is a brilliant and highly articulate person and who could undoubtedly say what she had to say viva voce in an affidavit. John Haynes also works for Corrections Service of Canada, and he described programs that were available to this accused and others in the system, and how this particular applicant coped with the system through his years in penitentiary. He refused to adopt a position on the parole eligibility question, or on full parole, quite properly, I thought. Parker testified himself. He married when he was in prison in 1986, Parker. He was 19 when he committed these three offenses in 1974. In 1986, he marries while he was at Kingston, and so both he and his wife testified. The stepson testified. Tom French, an ex-con convicted of non-capital murder, testified. He is active in prisoner assistance programs inside and outside the prison after release. He was a very entertaining and informative witness, but the jury obviously didn't listen to him. John McIntosh, the stepson of the applicant, testified, and Dr. William Comar testified. And I made an order at the preliminary hearing requiring the Attorney General to pay for an up-to-date psychiatric evaluation of the applicant. Comar did it. Didn't terribly help the applicant, I may say, but Ms. Leonard had no option but to call him. That's the price you pay. That's the risk you run in these cases.
I think it's important for, just in view of what you said, Your Honor, that defense counsel convey to the jury in a very meaningful way that simply reducing that eligibility period doesn't automatically mean that the individual is going to be free the next moment. Firstly, it's just eligibility, and as was stated at the outset, the applicant, even if the eligibility is reduced, then has to go to a full parole hearing. He's merely just eligible for the hearing, and that even if granted parole by the parole board, it might not be an automatic progression to full parole. It might be step by step through day parole, halfway houses, ultimately when enough improvement is demonstrated that ultimately full parole is granted. And finally, that someone convicted of murder, life imprisonment, is really on parole for the rest of their lives. And that's an also important message to convey to a jury, that there is some degree of supervision over that individual applicant forever, and so that they can assuage any concerns that the jury might have that this individual may reoffend if simply left to his or her own devices to reintegrate into society the next moment.
I should add that there is another rich motherlode of information available to the bar in the form of the transcripts of these prior proceedings under this section, because the rules have provided that full transcripts must be prepared of all of the proceedings in every one of these cases. So if you're looking for precedents, just find out the name of one of the prior cases like Viancourt or Parker, et cetera, and you can get access at the court offices or in the Crown office, I'm sure, to transcripts of the charges by the judges in the prior cases, the lists of witnesses, what they had to say, and so on. You've got a tremendous set of precedents out there in the local registrar's offices that you can access and utilize in your preparation for your cases. There's some questions that perhaps we can deal with now.
One question, can the report under Section 59, the parole eligibility report, include the recommendation by the initial jury under Section 744, which presumably expressed the initial interest of the community, or are they limited to the considerations of rehabilitation? That issue did come up in Valancourt. Valancourt was sentenced to hang. But before we got to that stage, the jury was entitled to make recommendations as to clemency. And I believe the vote in Valancourt that was transmitted on the record was 10 with no recommendation, 2 with a recommendation for clemency. That was allowed to be put to the jury on the 745 application. It was put into the agreed statement of facts. So by now, if the Chief Justice, and that was done on consent, there was no issue with respect to that. So whether or not the jury's recommendation to increase the parole eligibility period between 10 and 25, if Valancourt is precedent for that, the rules are silent. I would say that they would be entitled. I believe His Honor, however, may have a differing opinion.
Well, I simply disagree because it's an advisory opinion of the jury at the first trial. I'm not clear that anybody should know what the vote was to that detail as it was specified in that case. I don't think it's relevant. Simple as that.
My submission, Your Honor, would of course be that the jury had the opportunity to observe all the witnesses at the original trial, and their recommendation, certainly not binding on subsequent juries, is relevant. But
we're supposed to be dealing with the man 15 or 20 years later, and not the man that was tried. Although if it's the same man in every sense, psychological, social, and every other way, then of course he's going to lose on his application. Are there some other questions?
Yes, 2 more questions, and the first of these is apparently directed to both Paul and to Mr. Justice Killeen. In the cases where the jury set the next review date at 10 years in the future, did counsel make submissions on that point specifically before the jury began its deliberations? And this apparently is taking into account the language of Section 745 sub 3, which indicates that where the jury determines that the parole ineligibility period ought not to be reduced, the jury shall set another time at or after which an application may again be made for reduction of that period. Paul?
No, I didn't make that submission. The jury was creative enough to come up with that on its own. I was opposed to a recommendation for release at 15 years, but just in general terms, my recollection is I wasn't specific, and in fact, my expectation was that the jury in Valancourt would have sought it off somewhere, because there were some redeeming features, not a lot, but there were some redeeming features to Mr. Valancourt, and I thought they would have reached a saw-off and said 20 years, but in fact, the jury found no redeeming features apparently, and it was the jury themselves that came up with the creative solution of setting the next date at the end of the 25-year period.
To cut him off at the pass. In my case, Parker was a 20-year lifer under the decision of the trial judge, so he had 5 years to go at the time of the application last September. And again, the jury did what the earlier jury did in Viancourt, fixed it contemporaneously or coincidentally with the 20-year date. There was argument by both counsel about when they should do that. I can't remember the precise details of the arguments. I told the jury that they could pick any date because that's the way the section reads. I agree that there's a problem with picking the date at the end of his otherwise specified period of ineligibility, but because it's a cynical kind of approach to the power that is given to the jury to fix another date, they've foreclosed him. The section seems to be speaking about giving this man another shot, and the effect of these two determinations by these two juries is to deny him another shot. But there's no prohibition in the language against doing what these juries did, as it seems to me, even though it's cynical. But the cynicism reflects their attitude to the merits of the application, obviously, and how can we quarrel with the cross-section of the community that we get on the jury doing that?
Both juries were out about 2 hours as well.
2 hours or less. They were pretty quick.
And the second question, and I would think our final question for today on this panel at least, is if the original trial were for first-degree murder but led to a conviction for second-degree murder, would not the offense that is the subject of the application within the meaning of Rule 50.10 sub 2 be second-degree murder, and therefore, on review, the applicant would be entitled to only 12 peremptory challenges to the jury panel? And on my reading of Section 50.10 sub 2, I would agree with what the person posing this question has asserted, that the offense that is the subject of the application is that of second-degree murder and carries with it then 12 peremptory challenges for both parties.
That's probably right. Are there any other questions? Thank you very much, ladies and gentlemen. That completes this proceeding.
Wanted to know